We should be good. I've got my email open if you're sending them to me, and I've made it so anyone can share their screen if you prefer to share it on your end. But up to you. And Robert's coming in now. I'm just setting him in. So
Great, hang on. All right. Yeah, you got the first two should be going through the cyberspace to you.
okay.
Hopefully they don't take too long.
Yeah. There we go.
All right. You mind if I go ahead and share the screen? We're gonna start with 28 if that's okay.
Yeah, that works perfect. You should be able to share it.
Let me know when you can see it.
Yeah.
Is it big enough?
Yeah, it looks good.
Okay. All right. So we've attempted to sort of simplify 28. I think largely in 28, we're after the same things. I don't think we have major substantive differences. I think we have had a lot of disagreement on best how to word it. So let me kind of talk about the way we've structured it. We haven't really made any changes to A. A has been pretty stable over the last several proposals. So here's what we're trying to sort of establish. The first part is we've cut out the end, and let me sort of explain why. I don't know if we need to predetermine the way that you all have to respond during collective bargaining to only be restricted to any particular issue. Like the way that it was worded was it says kind of what you have to do and not what we have to do. Whereas I think the idea is we want to engage in bargaining if the situation arises. And the way that we've sort of reworded it here is we want to constrain sort of as follows. If it's not specifically, and this is one of the new things that we hadn't put in previous, but we just want to make clear, A is sort of the default, right? That this would come up. In other words, we are effectively legally compelled for some reason to have to make a change, right? So in those cases, this is how we're going to behave. And like I said, we've sort of covered this ground relatively in depth for multiple times. I don't think we have any questions left on A, at least in this last couple exchanges we haven't. So I guess what we're trying to say is we want to make it clear that only in those sections, so these are two distinct situations, if we're not legally compelled, then we do it. We have to satisfy, and again, it's adopt a new regulation or amendment to an existing regulation, policy, or resolution. So it's the same phrasing of all the types of documents. We didn't change it. I know we had some questions about those before. We're not changing any of the document names. That has a direct and substantial impact on wages, hours, or any other term or condition of employment set forth in this agreement, which is basically the mandatory subjects of bargaining, right? Or anything in the agreement, meaning if it's, because I know one of the concerns that I thought we heard from you all was, look, if you constrain it only to the mandatory subject of bargaining, and we have subsequently bargained a provision that goes beyond a mandatory subject of bargaining, but it's in the contract, we sort of want to have an opportunity to deal with that impact. So we think that that's contained within set forth in this agreement, meaning if for whatever reason it's not a wage hour, but it's in the agreement, then we would still be obligated. The university shall satisfy any legally required collective bargaining obligation with respect to the change prior to implementing it for members of the bargaining unit. And one of the reasons that part is really important to us is because if we're required to have a regulation, and I don't think it was your intent for it to read that we would be barred from implementing it for a non-bargaining unit member, but with the previous language, it certainly left that interpretation open, and it wouldn't really make sense necessarily legally because this contract can't constrain the rights of somebody who's not covered by the bargaining unit. We just wanted to make it clear. So again, I mean, we would not, there's nothing in removing lines 16 through 26. There's nothing that prevents you from choosing those options, like if you wanted to do that. But if the situation arises, if we have to satisfy our collective bargaining obligation, these are all options that are open to you or we didn't satisfy that. So I don't think there's necessarily, we don't think there's a reason to enumerate those because, I mean, that's how it would work. Just because that's the way, I mean, we have to bargain with you about it.
Right.
Again, in the context of it not being required. So really it's the difference of A is impact bargaining and B isn't, really is kind of the difference.
Okay, so I guess for B here, I mean, obviously this is something we're gonna have to take some time looking at and like thinking
Yeah,
through to make sure this will
sure.
cover. For B here, what happens if we go to this legally required bargaining obligation, right?
Yeah,
And the GAU does not, agree to something that fits with the regulation the university has provided. The university's made a new regulation. We go to bargaining because it contracts with the contract. It goes against the contract. And we
Mhm.
say, hey, we're not actually interested in having this new rule applied to in-unit members, right? What would
Right.
happen in those sort of circumstances here, you know?
So I mean, I'll ultimately defer to Shane to make sure I use the right verbiage, but the bottom line is that in that situation, if in a general sense, not talking about any specific case, and
Yeah.
obviously nuances could apply in legal standards, but in a general sense, if a party takes an action that constrains and constricts the contract or violates the contract, you would probably have a couple avenues open to you. You could probably file either an unfair labor practice for us to fail to bargain, or you could also file a grievance. But certainly, if the way you describe it is the case, that we just sort of unilaterally change the contract and we can't point to a reason other than, for lack of a better term, and to be somewhat cavalier about it, we just decided we wanted to. I mean, the way that the collective bargaining laws work, you would have a very strong case to file and appear before PERC.
Yeah, and I understand that. I think my thing would be, what would happen in sort of that meantime, in a very general sense, we had very specific language before about, it would not be implemented to the bargaining unit
Mhm.
during like negotiations and afterwards and things like that, right? Like in those
Right.
instances, would there be times where that regulation would be applied to the bargaining unit while we're going through that grievance process, And those are things we have to think about to make sure we're not putting GAs in those bad positions. And that might not be something that has any answer because that's how like each regulation would be different and it would have different things. But
Yeah. No, I certainly understand what you're saying. I mean, you're talking about in the in-between time, right? And I
yeah,
think for our understanding, and again, Shane, feel free to jump in if you'd like, or anybody on the team, feel free. But the bottom line is that that is really kind of the almost the definitional difference between impact bargaining and substantive bargaining is when, if we're legally required to take the position that we're legally required to modify the contract unilaterally. And even after there's an obligation we have to announce that to you. In other words, say, look, GAU, we realize the contract says X. We are under a government requirement, federal requirement. There's been a state law change, whatever, that we have to do this. Like, and this is the date we have to start doing it. We're telling you, we want to go ahead and bargain the impact of that change because it's not that we don't have an opinion about whether or not we want to do it. We just have an opinion that we have to do it. Typically in those cases, we have to conform to the law, but continue to engage in the bargaining of the impact.
right.
There is no allowance. It's trying to like prove that something doesn't exist, which is kind of hard to do. That I can't point to something. I'm going to answer questions sort of in reverse. I can't point to anything that would permit us to do that, as opposed to saying this is the thing that says you can't do it, because it flies in the face of the way that the contract is supposed to operate. To just say one party can just unilaterally make a decision with no like externally forcing grounds, you know what I mean? And just be like, just basically tell the other side to just deal with it.
Okay. Okay. Yeah, I think we're on the same page there. Those are just, general things. I think we'll have to talk more and make sure
Yeah,
we
no, that's
we fully
no, get that.
are on the same page and we understand what this says. Hannah and Ava, do you have anything you want to ask about this?
I'm good. I don't have a question necessarily. I just want to kind of inform people who might not be familiar with what we're doing. Is that okay for like one quick background second? Um, this is something that we've been working on, especially with all of the onslaught of legislation that's been coming, which we were kind of foreseeing when we started talking about this a year ago. But this is hopefully to give us some extra reinforcements in if something like a new state law or a new Board of Governors policy comes down, that we'll be able to have a little bit more extra say in how it gets implemented into the contract. That's just the purpose of the enumeration. So thank
Yeah.
you.
And last time we had to go through sort of impact bargaining, there were some questions about how that process worked and making sure, how do we go about this and navigate this? And this should answer, any of those future questions. So both sides know, hey, this is what's going on. This is how we go about that process. So we don't have to deal with that sort of confusion moving forward. Yeah, so we'll take a look at this, Patrick. Thank you for this.
Okay. And then so the other one we have for you is actually Article 8, which you should have in your email. I'm going to go ahead and share the screen. So I'm not going to lie, I'm pretty hopeful about this one because I do think that we've been able to meet 2 of the 3 asks, right? So here's what we've done in this version of it. We heard you loud and clear that the 12-month reset of the timeline was of critical importance, and the exchange of the 12 weeks was not sufficient. So what we're suggesting here, and we think it's a good counter, and we'd really like you to consider it, is, we have an interest in having the standards in 8.1 of which people qualify be standardized. So you will see that this counter does again remove sibling, which was the only category that you all had sort of said, look, we really want to keep having the sibling option. And we said, look, it's actually for the purposes of administering the leave program and the contract, while we really want everyone to be exactly the same, it's more important to us that you have the 12 weeks, but we will hold on to the previous language of the 12-month reset with the 12 weeks if you can agree to go with the standard relationship qualifiers. So, before our offer was, look, we need sibling out, we'll give you the 12 weeks and we go to a 24-month reset. We're saying, look, here's what we'll do. We still want the sibling category removed. Again, by the way, I just want to make clear, like I said before, if you are either the legal guardian, power of attorney, or in the process of receiving those, that still qualifies, because that's, what I'm saying, that's a legal dependent relationship, but only for the ones that doesn't apply. So I just want to make that qualifier again, because it doesn't explicitly say that, but that is in there in line 10. But we will go back to saying the current 12-month reset is okay, and we'll go to the 12 weeks.
Okay, I appreciate that. Ava, if you want to go first, yeah, of course.
I just want to understand more UF's perspective on like the necessity to standardize the language. Like I understand that other contracts that you have and FMLA or whatever, they might not include sibling, but why is it so crucial for UF to go back on this established language to make it standardized, whereas it has already been like UF already agreed to have sibling in there.
Yeah, I mean,
brother and sister.
it's a fair question, Eva. Like I said, I mean, I think the difference between, we're adding 50% to the length of the paid leave. So it's not as if we're asking you to give it up for nothing. What we're saying is, if you're willing to drop the sibling, we're willing to give the additional length of paid time off. And in fact, at that point, of all the bargaining groups under this structure, GAU would have the most generous version of this leave out of every single bargaining group on campus. I take that other than how it applies to PBA.
I completely agree, and with what you're saying, that you are making an effort and you're actually providing a counter, right? For something that you want. I don't understand the necessity, right? And I think it would be helpful for our team to understand that before we make any decisions on these. on this.
You mean, what is our interest in standardizing the leave program?
Yeah, why is it so important?
Well, I think a couple reasons. One, I mean, there's obviously the just ease of administration of the contract, but barring that, I think one of the other components is the fact that you know, in something like this, when I mean people are normally not asking for this when they are unless they're experiencing something very difficult for them to get through, right? They're obviously having either their own personal medical condition or the medical experience or something similar of somebody very close to them. It gets very difficult as an employer to say, well, this type of employee, for no other reason that they're this type of employee, gets this level of benefit, but this other person over here, this type of employee, gets a different level of benefit for no other reason than the fact that they're a different type of employee. You know, there's nothing, to your point, there's nothing that prevents us from doing that. I mean, there's nothing that prevents us from doing it. You're 100% right. We're not obligated to do it, but our interest is in that, you know, aligning what, by the way, is an extremely generous leave policy compared to what you're going to find other places. And you guys don't expect me to be answering. I can't talk and also answer these comments in the meantime. I mean,
The comments, I mean, that's primarily, I mean, GAs are allowed to speak in there as long as they don't, you know, unmute themselves. That's, we'll read those and discuss those when we go to debrief. That's,
Okay.
your team does not have to worry about those. I did make a
Okay.
note for people not to make any personal comments, so if any of those come up, we can discuss, but that's just for GAs to talk, and you don't have to worry about
Okay.
those too much. We'll discuss those. Hannah, what do you got?
Yeah, I don't mean to pile onto this. I think if I can pick out one of the things that Ava said, we were under the we thought that UFF has sibling in their definition. So as you're saying standardize across, that kind of goes counter to what we know to be true.
Well, to your point, Hannah, for what it's worth,
Uh-huh.
we are in the process of bargaining them, but we have TA'd in them. It's Article 21.
Mhm.
And it's not included in the new TA. It hasn't been ratified yet, but it's not in the TA that we just signed with them.
Okay, we'll follow up on that. Thank you.
Yeah, but you're welcome. You're welcome to. I mean, it's really kind of sketchy, like when you start going back and forth. I mean, I understand to Eva's question, the answer is we're trying to standardize. That process is still in bargaining. You know, I mean, I don't want to be perceived as saying, well, this is what we gave, you know what I'm saying? Like, I don't want to present their article that I'm bargaining with them to you, but the general interest
I understand.
question is we're trying to standardize it.
Yeah, and I just want you to know that might be why we're kind of pushing you on this, is because it's kind of going counter to some information that we have.
I respect that. No, I respect that and I appreciate it.
Yeah, I think as well is like when we have to think about you know, the inclusion and definition of immediate family. I mean, that changes a lot about you know, a lot of how these things are applied. And so we have to think about what GAs are going to do. GAs are typically, I mean, they're younger than a lot of faculty and stuff. And when we're younger, I mean, I have 3 siblings, and I'm not going to say I'm amazingly close to them, but I am good friends with them. And you know, God forbid if something bad were to happen to them and, you know, they would either be in a serious injury or even die, you know, I would want our contract to protect my right to say, hey, I can go to their funeral. And they're not distinguished from my parents as being able to do that. And with our current contract language, you know, with the addition of bereavement, that's something that GAs can rest on. And I understand bereavement's new. It's, you know, that's not something that we've had before, but I think excluding sibling from that, that would be something that would be, I think, a really tough thing for some GAs to swallow, which is why I think we're seeing some comments about it. Obviously, the extension of paid leave is generous. I'm not going to say it's not a generous increase. It's a 50% increase, and we do respect that. But I mean, we're going to have to go back and talk to GAs and say, hey, what, you know, is more important to you at the end of the day? You know, this kind of protection that you could, you know, you have like paid bereavement leave for visiting your family. You know, you could take paid leave to visit them in case of a serious injury for your siblings, or they can't get longer paid leave, which again is a benefit. But I think it's going to be a really tough sell, especially since our current contract language does include brother and sister, and I'll be honest with that. But I mean, we appreciate this. Obviously, UF has done some work to try to get this done, and we're almost there. So, you know.
So I just want to make one clarifying statement, Austin, is the paid leave provision is not intended for bereavement. That's why we have a separate, you know what I'm saying? Like
Yeah, no, I was saying having sibling in the definition of immediate family would affect bereavement because that's defined by immediate family. And then paid leave also includes a serious health condition of an immediate family member. So it would also affect the cases where a sibling is in an immediate serious health condition.
Yeah, I got it.
It would affect their ability to take both of those for their subsequent reasons.
Gotcha.
Mhm.
And then I think the rest of it, the rest of it was not a change. I mean, I think you guys had met what we had previously asked on bereavement of the 4 and then the 6 unpaid. So I mean, the rest of this should be the same as what you should see. I mean, I think those are really kind of the 3 components that we're really left talking about is, the qualifying definition of immediate family, the reset clock of the paid leave, and the length of the paid leave.
Yeah, and we appreciate that. So
Yeah, I would also say too, I did not do this, but I could pull the data if it matters, and maybe it doesn't matter. Maybe it's more of a philosophical position, but I'd be happy to do this. What are the number of people that have taken leave, for which reason, right? How many people took it due to, having a child of their own or a parent getting sick versus how many people availed themselves of the benefit for a sibling? I don't know if that would be compelling information to you or not. I'm not, I mean, I don't want to try to use the data if you're like, that's not it. This is more of a philosophical thing for us. We really don't care about the data. So you let me know. I don't mind going and asking the leave team to produce that. But again, I also don't want to beat you over the head with data if that's not what this is about.
I think the data would help.
Yeah.
I mean, we're obviously going to go on our own and we're going to talk and with GAs and get obviously their philosophical response to this and see what they would prefer because it is a kind of thing. But the data would help just in sort of a general sense. I'm not saying that's the only thing that would help us make a decision, but I wouldn't detract from anything for sure.
Well, and honestly, Austin, I don't know. I mean, I could ask them and they could tell me that we've had 90 applications in the last 12 months and 75 of them were for siblings. I have absolutely no idea. So, I mean,
Yeah. Yeah. So yeah, I mean, that I think would help us. Yeah.
so it's heads I'm wrong, tails I lose, I guess is the, it's hard for me not to look at that because it's coming in the entire time. Well, I mean, if that's the case, this is one of the reasons, by the way, I don't like doing this on Zoom. I mean, if that's the case, we could just go to current contract language, give you guys 8 weeks and be done with it.
I think the comments those are GAs and we give them the right to talk in the comments. I don't know if there's a way for you to mute it so you don't have to view them as they're making those comments, but
No, it's fine.
those
It's one of the
comments are
problems.
for us. They don't represent what GAU's final decisions are going to be here. So
All right. Well, if it's okay with you, Austin, we're gonna go ahead to caucus. Like I said, we had a couple questions on a couple of the other ones that the team has been working on throughout the days, back and forth. We may be able to come back and present as many as 2 more.
Okay.
If not, those will have to wait until next week with possibly whatever else is on our side. But I'll shoot you and your team an email, relatively shortly. At the very least, the latest you'll hear from me is probably 15 minutes with we're not going to be able to come back. So
Okay.
you'll definitely hear from me one way or another within the next 15 minutes.
Okay, that sounds
All
good.
Thanks.
For GAs in here, just hang out for just a second. And we'll get our own caucus debrief set up. Are all of them gone? They are all gone. Okay, I'm gonna send a fresh Zoom link in the chat unless Hannah or Ava beats me to it. They beat me to it. By far, they beat me to it. So hit on that. I have to open the other Zoom. So thank you, Yazin, you just joined us. We're going to the debrief. So click the link in the chat. I know it's confusing. You'll have to wait in the waiting room for about 2 minutes. And then you'll be good. Make sure you get the passcode. If you don't get the passcode, you won't be able to get in. So click that debrief link. Isabella, thank you for joining us. We're going to the debrief real quick for like 10 to 15. I'll send the link in the chat again.
See you there, Austin.
See you there. I will open it as soon as you see like most of us leave.
Got you.
So click that click that cool link. I found like I'm on repeat right now, but hit that if you want to come with the debrief. We'll probably open this chat up again in like 15 minutes, but I'll have to end the call for at least a little bit.
Sorry, I accidentally jumped off before grabbing the passcode, so
You're fine.
just
Yeah,
hopping
no,
back on.
you're good. Anyone else who wants to join us in debrief, hit that link. Benjamin, you just joined us. They made a really quick couple of presentations. We're going to debrief really quickly. There's the link again. Sorry if you were already here. Yeah, there you go. The link, the passcode's there for you. No problem. Okay, I'm going to be ending this call now. So see you there, team.
I'm so sorry. For some reason, it won't let me copy and paste it, so I'm gonna write down the passcode.
You're fine. The passcode's a little weird. So yeah, the passcode is at the end of that link. If you click the link, it'll probably just take you immediately and you won't get the passcode, but passcode's there. I wish I could just like send it out. It's also in your emails
Okay.
each week. So do that. We're gonna go to the debrief. I'm gonna close this call in like 5 seconds.
Okay.
4, 3. Are you good, Isabella?
Sorry, can you send it? It
Oh,
disappeared. I'm
yeah,
sorry.
all right. There you go.
Thank you so much.
No problem. Once you say you're good, I'll close it. But
Okay, 6, 9, 7, 1, 1, 8. Okay, I'm good. Thank you so much.
no problem.